Good evening, Namibia, and welcome to the Wheels of Justice, where we navigate the law and justice system and how it impacts the lives of everyday Namibians. I'm Daniel Nadunya, presiding over this session, and tonight we are going to dive into one of the most important pieces of legislation for our democracy, that is the Electoral Amendment Act of 2024. This new published act, as published in the Government Gazette on October 8, 2024, brings significant changes to the electoral landscape of Namibia, and we'll discuss how this affects public servants, council members, and the electoral process in general. We'll be back in a jiffy. Justice with me, Daniel Nadunya. Tonight, we shall look at the Electoral Amendment Act. That's Act 8, 2024, and its impact on our democracy. And joining me in the studio tonight are the two esteemed guests, who are well versed in law and in the subject matter. That is Mr. Etuna Josua, the Chairperson of the Law Reform and Development Commission of Namibia, and Ms. Loide Shaparara, a Senior Legal Officer at the Office of the Attorney General. Leonard Friends, thank you so much for making time for the Wheels of Justice.
Thank you for having me.
Now, Mr. Josua, again, as part of welcoming you as you make your debut appearance on this platform, is there any point in limine that you would want to raise, or basically you can have an opportunity to present your maiden statement? I mean, you assumed responsibility at the Law Reform and Development Commission of Namibia just recently. Perhaps as part of your maiden statement, maybe you can take us through what your mandate is and how has it been thus far?
Thank you very much, Daniel. Our mandate as a Law Reform and Development Commission is to examine all the areas of law in Namibia and to make any recommendations for the amendments or reform thereof. That mandate includes also codification of the customary law and harmonizing customary law and common law with statutory law. And it also includes reviewing all areas of law in order to ensure that they are consistent with the Constitution, especially in terms of Chapter 3, which deals with fundamental human rights for all individuals in Namibia. And then, of course, we are still obliged to examine any areas that are assigned to us by the Honorable Minister of Justice. So if she assigns any area for us to research and to examine and to make any recommendations, we are also bound to do so.
Yes, and how has it been ever since you took over the reign as the chairperson? It's
been going very well. Well, I have served in the previous commission as a deputy chairperson, and after the Honorable Minister, current Honorable Minister of Justice, was appointed as the minister, I took over, and I have been acting as the chairperson until that term has ended. And so this role is not quite it's not quite new to me.
Yes.
And in fact, we were able to continue with some of the projects that were incomplete in the previous tenure of the commission, and the research that led to the amendments that we'll be discussing today has actually commenced during the tenure of the previous commission on which I served as a deputy chairperson.
Right. No, thank you so much, and again, we are pleased to have you. Ms. Shaparara, that does not, let's not prejudice you. Any point in limine?
Daniel, I think I wish that this discussion starts against the background that the Constitution, the Namibian Constitution, provides for the right to participate in political activity. I think it's a right that was hard fought for, and provided that you are over the age of 21, that you can assume political office. So we are actually, the discussions around and the amendments was actually informed by constitutional provisions. And that the Constitution explicitly, I don't want to say disqualify, but requires that if you are to take up position as a public office bearer, you are expected to be unremunerated.
Right.
So this amendment sits between those two constitutional provisions.
Perfect. That's good. Perhaps, and we are going to delve into that subject matter extensively, I believe. But just before we get there, I mean, when we look at our electoral calendar for this year, I mean, we are at an advanced stage.
Sure.
As of today, the news is basically that there's a team that departed from Namibia to South Africa to observe the preparation or the printing of the ballot papers. Basically, but that notwithstanding the complaints that we have all seen in the media, political parties basically contesting against the awarding of the tender to that specific company. Perhaps maybe what's your take? You've been following the development. What's your take on that?
I think, Daniel, the appropriate answer for this platform would be that we are in this legal system provides us opportunity to seek redress if we are aggrieved. And perhaps the correct response for any person that is aggrieved, and probably justifiably so, is to approach the forums that are available in the legal system and to take up the issue.
Yes.
Yeah.
But Mr. Joshua, we've also seen that the Landless People's Movement have also, served a demand letter to the Electoral Commission of Namibia. I mean, given that demand letter, which basically says failure to hit to the core, it will result in some kind of court challenges. But we've seen that political parties makes up a team of those that are going to South Africa to observe the printing of these ballot papers. Now, these demands becomes mere academic, isn't it?
One of the threads running throughout our electoral law is the aspect of transparency and openness. So that means every aspect of the electoral process takes place in an open fashion whereby all the stakeholders are entitled to be present and to observe the process and thereby satisfy themselves that everything is going according to principles of fairness, so that at the end of the day, they can be assured that the process is free and fair. So against that background, of course, one also takes into account the fact that there's electoral tribunal and electoral court and the High Court. Basically, all the institutions to which one can go for redress, their doors are open all the time.
Yes.
If one has a valid grievance, they are free to approach the courts.
Yes.
But of course, the avenues of openness, of being present to observe the processes of production of election materials and all other processes, those avenues still remain open. So.
Thank you so much. Of course, today we are here to basically speak about the Electoral Amendment Act of 2024. Perhaps let's begin by unpacking the basics of this Amendment Act. Now, for members of the public out there, the new Act provides provisions for the public servants or members of the National Council and other government officials to stand for National Assembly elections while managing their positions and retirement. It also addresses certain exclusions for military, police officers, intelligence officers, and correctional service members. Perhaps, Ms. Shaparara, what was the status quo before this amendment, and perhaps what necessitated this amendment?
So like I mentioned previously, Daniel, the amendment sits between the right to political activity and the qualifications that the Constitution provides as to what are the qualifications for assuming public office. And I will not delve into the specifics of it. And then on the one hand, there's the distinction between public office bearers and public service, or employees within the public service.
Yes.
So the public service has rules, and one of the rules particularly is that you must devote your time wholly to the public service, and that you should be present between 8 and 5 in the public service. Yes. If failing which, you are guilty of misconduct, essentially. There is also the nature of public service is policy formulation. It's making decisions that will bear consequences far beyond any change of whoever is in political power or whoever occupies whatever political positions in the country. We have the public service, and that oversees and administers public policy, and the fiduciary duty that public servants hold in respect of the offices that they hold, yes, and the scope of influence to affect decisions. So in between the constitutional rights and this reality within the public service, it's the concern around if you are making yourself available, and you will be preoccupied with that, it will be detrimental to the public service to have you in office. It might even be risky to the public service to have somebody that has been nominated and is at this point certain.
You are required to be neutral, to be apolitical as well.
Yes,
once serving in the public.
Exactly.
Yes.
So it is, in essence, a bit risky to know that now that I know I am on a political party list, and obviously for the next 5 years my position is secured. If I am left in office,
yes,
it might be the realization that might be detrimental to public service. That is the rationale for this amendment.
Yes, thank you. Mr. Joshua, can you then explain how the amendment to the Electoral Act affects public servants who wish to stand for a political office or for that specific office, parliamentary seat?
In a nutshell, or
yes,
in other words, in short, members of the public service, and remember when we are talking about public service here, that includes employees of local authorities. That's our towns, villages, village councils, and municipalities, and so on. The impact basically is that they can contest without being compelled to resign once they are nominated to contest for a seat on their party list. And they merely take leave while contesting. That means from the period, I think it was from Thursday last week, when the nominations closed. That means that from that period until the date when the election results are announced, they are deemed to have taken leave. So they will basically be not at work during that period because they are contesting for their seat.
Deemed to have taken leave. Is it some kind of forced leave?
Exactly.
Right.
Exactly. That's the actual intention, that they are compelled to not be at work, to be absent. They must focus on their contestation for the seat. And if they do win, when the results are announced, I think by the estimates of the ECN, the announcement of the results will be around 30 November or so. So when the results are announced, if they in fact win a seat, then they are deemed to have resigned immediately. So that means there is no going back to work, except maybe to pack up their personal belongings.
Yes, perhaps while on that, and I would like you colleagues to assist me understand this particular leave. Ms. Shaparara, is this paid or unpaid leave?
So the provision provides that is within the scope of either your employment agreement or the law that governs your employment relationship. So in this instance, it will be the Public Service Act and the staff rules, and passed under the Public Service Act. So in terms
Yes.
of within that scope, it can be if that particular, depending on whether or not there's accumulated leave, vacation leave.
Yes.
You can use your vacation leave. If you do not have vacation leave, you would unfortunately or fortunately have to resort to unpaid leave.
Right.
So that is what the amendment provides. So if you have leave days, vacation leave days, you can use that. If you don't, that's what it is.
What then do you make of that, given the fact that I think one of the reason or what necessitated this amendment is basically to protect the income of those people that are affected or used to be affected in the past when this provision was basically not there. Now, if you don't have accumulated leave and you basically have to go on unpaid leave, that basically still means that you basically have to wait from the announcement of the results up to the date of the swearing in. That is when you take office. Basically, those 3 months you will still be without income. Can we then say that the amendment sufficiently protects especially the income of those affected?
So Daniel, I think a lot of when the amendment, the bill was discussed,
Yes.
a lot of that conversation arose, but when you read the long title of the amendment of the act, the Amendment Act,
Yes.
Protecting the wages of public service is not one of the objectives.
Yes.
So I think it was because you have to do some balancing. So what is permissible, and what cost would that have added to the public service, and would that have been in the interest of the public service? Are other additional and ancillary questions to that? So I think this is it was a fair expression that if you elect to go this route, there are risks involved, like all things in life. But within the scope of the Amendment Act,
So in the words
in
the words of Mr. Minister Carl Schlettwein, who said it should have been a conscious decision that an individual make to run for office.
I believe so too.
All right. Mr. Joshua, perhaps what challenges do you foresee in the practical implementation of these provisions on leave for public servants, especially in critical sectors such as health and education?
I think the possible challenges might affect the individual candidates concerned.
Yes.
Maybe in the event that they don't have sufficient leave days, they might end up having to take unpaid leave, because that provision is quite firm. You are deemed to be on leave. So they might have to take unpaid leave. But other than that, there shouldn't really be any other major challenges. Yeah.
Right.
I would want to add to that. I think one thing that probably benefits us, or that assists to be kind of lay down the prejudice to the sectors, might be the timing of our elections and the election calendar, because I think right at this point, especially in the education sector, it's time for exams. So
Yes.
there's no active classes, perhaps, that
Yes.
continues. I think in the health sector, from our media reports, we say there's a lot of saturation. So perhaps within the operational component, arrangements can be made to make up for the individuals. And it is also not a wide scope, because you have 96 is maximum across the country. So I don't think the numbers, in respect of the numbers involved, that is also, it will cause grave prejudice. And that the calendar is such that it's towards the time of the year that in the country generally there is a dwindle in activities. It's a December holidays, January, part of January is still a holiday and getting back, and then soon the election. So I think that also assists around mitigating the prejudice.
Mr. Joshua, do you perhaps think that provision of deeming public servants as on leave or that forced leave impacts administrative fairness, especially for those sectors that we've mentioned, particularly health and education?
Not exactly.
Yes.
In fact, the simple answer is no. As alluded to earlier, this is a conscious decision that a prospective candidate takes. And in taking that decision, they are really supposed to take into account all the possible implications, including also the implication that one is supposed to make a choice where they really want to be. You want to be a professional public servant,
yes,
or do you want to enter the political space? Now, what this amendment does, it facilitates that transition so that it can be as painless as possible, in the sense that as opposed to the previous situation before the amendment, at least now, once you are nominated as a candidate, you merely take leave for that period, short period, when you are contesting for the seat, when you are campaigning, busy campaigning, and so on. And during that period, your job is actually protected. In the event that you do not win a seat, you merely go back to work, and then you continue as usual.
Yes.
So that protection, that is basically the innovation, the key innovation that this amendment has introduced. So in terms of administrative fairness and so on, a question of administrative unfairness does not really arise. As a contesting candidate, you are actually required to have thought out all these implications.
It takes us back to conscious decision.
Yes.
You made a decision to basically run for a political office.
Exactly. And I think it's not my place to say, but to contest for National Assembly, you must always be nominated by a political party, which means there must be a big organization behind you, or your political party. If they truly believe in you, of course, they can use some other creative ways that they can make your transition easier.
To compensate you,
to compensate you, or things like that.
Yes.
It's also doable.
Great.
From my end on that question, Daniel, I think the objective of the Amendment Act is essentially aimed at facilitating administrative justice, because we don't want public service to become a politically volatile place, because we know during this time there's heightened emotion and rationale around this thing. So we want to leave it out. And if you are a public servant, we want your decisions should be fair, should be reasonable, should be objective.
Public service must basically continue unhindered by political events and so on.
Exactly.
Thank you so much. Now, the Act also brings specific provision. I think for members of the public out there, there is a provision that public servants over the age of 55 are allowed to retire instead of resigning after being elected to the National Assembly. This introduces a new dynamic into how senior public officials transition into political roles. Now, perhaps with that consideration, what are the implications of allowing public servants to retire instead of resigning, particularly for those who are in leadership roles in government ministries, such as directors and deputy directors?
So I think it's against the background that if you have, because if we are referring to early retirement, that's what it would have been deemed ordinarily in the public service. So the consideration is basically you are deemed to have resigned, and there's different legal implications, particularly in respect of the monetary, the remunerative component of it when you resign as opposed to when you go on early retirement. So I think it is to make provision that you do not want somebody to exit public service basically without acknowledgement, because I think if there's one thing that I could identify is the payment of severance pay. That is not necessarily applicable when you resign. But now, if somebody has worked for more than 30 years and they're at the age of 55 already, and as a token of we appreciate what you have done to the public service, your service to the public service, you get this option to go on early retirement. It affects the ultimate package that you will get, but I think it's a better package than if you would have resigned. So I think it's considerations about accommodating those that have served the public service for a longer period, and that would also have there's no opportunity for you to come back to the public service after this. That's the underlying fact. So if you're 55 already, by the time you've served as a public office bearer, you right into
60 and so forth. Thank you so much. You are still following the Wheels of Justice here on NBC, and this session is focused on the new electoral law that brings significant changes to our electoral process. In the dock is Mr. Etuna Josua, the chairperson of the Law Reform Commission of Namibia, alongside Ms. Loide Shaparara, that is a senior legal officer in the Office of the Attorney General. After a short break, we'll be taking your calls for your questions and or contributions. Welcome back, Namibia, and this is the Wheels of Justice. Your calls are now welcome. Should you have a question or contribution, please feel free to call us in the studio. The number is 061-291-3417. That is 291-3417. Your calls are now welcome. In the meantime, let the conversation continue. From a legal standpoint, does this retirement provision create a precedent for future amendments, perhaps to laws governing public service employment?
Not necessarily.
Right.
This particular provision has a background, and the background is that, remember, when we're talking about public service in this context, that includes employees of local authorities and parastatals. And during the research, we found that there are many pension funds that apply to these different institutions. The parastatals alone are more than, I think there's more than 70 parastatals in Namibia. And many of them have different pension funds, whereby there are different rules that apply in terms of retirement or possible early retirement.
Yes.
So this amendment does not create a precedent because in this context, it is meant to protect the benefits of the affected candidate.
Yes.
So while the primary provision says that if you win a seat in the National Assembly, you are deemed to resign, the amendment gives you, if you are above the age of 55, it gives you 7 days to decide and choose on the legal act by which your employment is terminated. Meaning you can choose whether to be deemed to have resigned, or you can choose to go on early retirement, again with effect from the date of announcement of results. And the reason for that is that the different pension fund rules provide, some of them provide different benefits based on whether you have retired or whether you have resigned.
Yes.
And to protect your benefits, you are then given that choice and consider, okay, which route will be most beneficial. If it's a resignation, then it's fine. If it's a retirement, then you choose that, okay, instead of being deemed to have resigned. I'm above the age of 55 now. I would rather opt to go for early retirement
yes.
because that's what I consider to be most beneficial to me. So, it's protective only in this context. It will not necessarily create a precedent for any other context.
Thank you. Let's hear from Mr. Dawson from Gibeon. Good evening, sir.
Good evening. Good evening. Thank you for the opportunity. Very, very interesting subject. You see, democracy. I do not know. Sometimes in Africa, I'm kind of confused how people understand democracy. You know, democracy can even cause destruction. Democracy is not that democratic as we expected it to be. It has a very negative impact on productivity in this country currently as that law is amended. You must look into, even at other electoral things, you see the teachers are going to work as electoral officials. And then they get leave from, or they go from the school and work in the field with ECS. That is a leadership gaps and poor planning at all levels of the system. So we must go back and get a proper definition or define of democracy so that democracy cannot be misinterpreted. For instance, democracy become majority, democracy become destructive, democracy become undemocratic. That's my contribution.
Right. I'm just perhaps failing to get the context in which this act that we are busy discussing today ties in with your contribution or your opinion.
You see, the thing is,
yes,
if you, for instance, you cannot butter your bread on both sides.
Right.
If somebody is in government administration or in public administration, in public work, in public service, let me put it correctly, in public service.
Yes.
And he wants to be at a political position. Then make up your mind and decide where you want. Because we cannot keep your job just because if you're not winning that position in politics, then you can come back. While there's others in the queue, millions in the queues, who are looking for that specific job.
Right.
So value your job, acknowledge your job, respect your job, or leave it so that others can get it. And go out and go for your politics if you want to be in politics.
I think you have made your point very clear. Thank you so much, sir.
Thank you very much, my friend.
061-291-3417. That is 291-3417. That is the number in the studio. Now, the Act doesn't only affect public servants. It also addresses members of regional council and local authority council. This conversation continues. We also want perhaps to look at how it affects uniformed officers. Perhaps it also touches base on uniformed officers, that being police officers, members of the security cluster, if we have to put it that way. How does the Act affect them, Mr. Joshua?
As you know, we have 4 categories here. We have the Namibia Defense Force, Namibian Police Force, the Correctional Services, and the Intelligence Services. All of these categories of service members, they are already prohibited by the statutes that governs their professions. They are already prohibited in actively participating in politics, especially to participate by way of becoming a candidate for National Assembly. So that exception that you find in this amendment merely reinforces that prohibition, which is already there in terms of those other existing statutes. And there is good considerations for that prohibition because of the nature of the work that these service members perform. If they are allowed to contest for political office, then it may have some other impact on public order or national security or things along that line.
Yes,
so,
our caller, Mr. Dawson from Gibeon, just basically said we must be very careful how we interpret this democracy, and especially practically. But is it democratic, Ms. Shaparara, that these members of the security cluster are excluded from, or perhaps they are excluded from participating into this democratic or right that they have to be elected, not only to elect, but to also be elected and serve? Is it fair that they are now excluded?
So Daniel, I think...
Is it even constitutional?
So within the parameters of the Constitution, like I mentioned at the beginning of our conversation,
yes,
all of us are constitutionally entitled to take up public office.
Yes.
So to that extent, it might be constitutionally challenging, I would say, at this point. But on the other hand, you also have the scope of their services. And I don't know if we could remember, even throughout COVID-19 and all that, these are a cluster that is essentially considered as essential services.
Yes.
But it's also the cluster, if you allow your Central Intelligence head, for instance, to leave his position with everything that that mandate entails, then it might be risky to the country to say that now this is the head of Central Intelligence is now on a list of this party. How are we supposed to feel safe? I think it creates that very unpleasant dynamic, yes, regarding national security and public safety and order. Yes. And I think based on that, it can qualify as a justifiable limitation on their right.
Can an aggrieved member of the force basically take to court and challenge this very provision and basically argue that it is unconstitutional, that their right is taken away from them?
I think that would be an interesting, it will be an interesting case, and also a very, very rich jurisprudence for the country, because it will necessarily ask the courts to pronounce on the balance between our national security, state security, and the right to participate and to make yourself available, which are two constitutional rights, yes, of equal importance. So that will be interesting to see how it unfolds, I would say.
Thank you so much. As we draw near the end of tonight's engagement, let's kindly look at the jargon of the day. Welcome back. We now take a look at the jargon of the day. Mr. Joshua, please, in simple terms, briefly explain to us what legislative enactment is.
Legislative enactment means the law is passed. That means the National Assembly, the National Council, and the President, they have all passed that law.
Yes.
With the President giving the final signature to it.
The law is now in force?
Yes.
Thank you so much. Ms. Shaparara, incompatibility clause, what is that? For a layman, it's very simple, briefly.
So, incompatibility clause is a provision that in essence provides for, it provides for the determinants of compatibility, I would say.
Yes.
So it specifies the requirements for either meeting or not meeting.
Yes.
Yeah.
Perhaps as we conclude, and I'm giving each one of you only 30 seconds, looking ahead, how do you think the Electoral Amendment Act will shape Namibia's future elections and governance structures? Briefly, let's start with Ms. Shaparara.
Ladies first.
Yes.
I think it will shape it for the better.
Right.
It is trying to clear out some nuances that has not been clarified before. And like I said, will help us with keeping public administration, public service apolitical. And
Right.
that is a commendable objective.
Thank you so much. Mr. Joshua?
I think the full impact of this will not be felt in this election, although it has started. But in subsequent elections, we will find that this amendment will open the door to people with leadership experience from local authority, regional council, and public service, and parastatals, also for them to contest in the for seats in the National Assembly.
Yes.
It will make democracy even more dynamic, and
Yes.
it will widen the options available to the voters by making it easier for people with that leadership experience to bring their experience and particular backgrounds to the National Assembly.
Thank you so much.
Very much.
So before I hit the gavel, thank you so much, Mr. Joshua and Ms. Shaparara, for your valuable insight and contribution tonight.
It's my
Thank you for
almost
having us.
pleasure. Thank you for having us.
The wheels of justice continues to turn, and it is through laws like this that like the Electoral Amendment Act that we navigate our country's democratic journey. To our viewers, thank you for always being with us. Keep watching as the wheels of justice will continue to discuss the laws and legal matters that affect us and affect our daily lives. From me, Daniel Nadunya, I now declare this session adjourned.